broadcast of Kennebec Valley Forum is being brought to you by the Elder Law Offices of John and Mark Nail Law Offices, located at 58 Elm Street, Waterville, Maine. Give them a call at 660-9191 or visit them on the web at www.nalelaw.com.
Welcome to another edition of Kennebec Valley Forum. We're joined here today with John Nail to talk about trust. Welcome, John, and tell me, what is a trust?
What is a trust? Let's see. In the simplest terms, a trust is a legal document that is recognized in the law as being legally enforceable, and the terms of the document are going to dictate or set forth how assets are going to be held in trust, usually by another person called the trustee. It could be a person, it could be a bank who serves as a trustee. And that legal document, that trust document, is going to tell that trustee how to handle the assets, what to do with the assets, how to invest the assets, how to distribute the assets, when, to whom, who the beneficiaries are. And it's called a trust because that's exactly what I'm doing, or what the person is doing. The person is taking their assets and they're going to trust that you, or the bank, is going to handle their assets, protect their assets in such a way that is set forth in that trust document. The trust document, for all intents and purposes, really creates another legal entity, and that entity has certain obligations as set forth in the trust document and certain obligations as set forth under the Internal Revenue Code and under the terms of our Uniform Trust Code, all to make sure that the assets are protected, that the trustee acts in a fiduciary capacity, that taxes are paid, funds are collected, assets can be sold, and then like the purpose of the trust is really going to control the terms of the trust.
Explain that a little bit.
Well,
when we enter into a trust, I'm going to trust you to see that my property is taken care of, and I'm going to put it into a trust so that at the end of the day, when I'm gone, my wishes are going to be carried out through the trust.
You don't mean the end of this day, though.
Well, no, I hope not.
So what Clyde is saying is what types of trusts are there? And what goals or what purposes could there be for the trust to accomplish? Well, the most common type of a trust is a revocable trust. And the main purpose of the revocable trust is so that at the end of the day, as Clyde says, at the end of his day, a new trustee comes in and distributes the assets according to Clyde's wishes. Except with the revocable trust, all of the time that Clyde was alive, he had complete access to all of the assets that are in the trust. And then when he passes and the new trustee steps in, there's no need for the probate process. The trust did not die, so the assets do not need to go through the probate court process. A new trustee simply steps in and makes a distribution of Clyde's assets, just like somebody would do under a last will and testament, except where the last will and testament needs to be administered through the probate court and the probate process, the trust agreement does not get administered through the probate process and the probate court. So the main purpose of the revocable trust is to leave a person in complete control of the assets during their lifetime, but when they pass, the assets can then be distributed to their children or other family members or whoever without the need of that probate process. And the probate process, as we know, can be expensive.
Yes.
It can be time-consuming.
Absolutely.
And it can put a lot of strain on family members in terms of going through the probate process. But with the trust process, the owner of the assets that put the assets into the trust passes away, a new trustee comes in, makes distribution of the assets without the need for the probate process. So the main goal or the purpose of the revocable trust is to avoid the probate process and provide for an orderly distribution of a person's assets when they pass.
Okay.
That's the revocable trust.
Well, how about a joint revocable trust?
So a joint revocable trust would be one established by a husband and wife, most commonly husband and wife. And again, it's revocable, so they each can use the assets as they wish. It's just like it never left their bank account. It's titled in the name of the trust, and probably the husband and wife of the joint revocable trust serve as trustees. And it says that upon one of us passing, the survivor just simply can continue to enjoy the assets that are held in trust. But on the last of the joint couple, then it gets distributed to the children. So we have a revocable trust where there's one person who established it. On his or her death, a new trustee steps in and makes a distribution. Then we have the joint revocable trust, usually done by a husband and wife who want to avoid probate. And the trust document just really kind of takes the place of the last will and testament, except now the distribution of the assets happening on the last to pass of the husband and wife team. Then the assets get distributed at that time without the probate process.
And what happens, as we talked about the couple, one deceases the other. Does that leave the remaining partner with 100%?
Yes, it would leave the remaining partner with 100% of the assets, except in the circumstance where we're dealing perhaps with a second marriage, and there are children born to each of the parties from a previous marriage.
Okay.
Then what we want to do in that circumstance is we want to make the assets available to the survivor as long as he or she needs them. But on that person's passing, then there's a distribution plan that calls for certain assets to go to one spouse's family and then certain assets to go to the other spouse's family.
Now, does it have to be equally divided?
No, it does not have to be equally divided. No, usually how much goes to each family or the children of each of the married couple usually depends on how much that person had when he or she came into the marriage.
Okay.
And usually it's that amount that that person would want to go to his or her children.
Okay. All right.
So that's a kind of a what we call a blended family planning situation, which is quite often overlooked, but in reality, very important. It should be looked at.
The other thing I'm full of questions today.
Good.
We have this trust set up, okay? And using me as an example, I have 4 or 5 different pieces of land. I get married. My partner has 3 or 4 pieces of land. So now we have about 8 pieces of land together. How many can we put into that trust, and how do we do it?
Okay, so a person can put whatever into a trust. Savings accounts, real estate, jewelry can be in a trust, real estate can be in a trust, okay? So any amount, any number.
Okay.
But the thing is like when we establish a trust, then we have to fund the trust because it's only the assets that are then titled in the name of the trust that are going to be governed by the terms of the trust. So in your situation, you have 3 or 4 pieces of real estate. We would need to draft 3 or 4 deeds from you as an individual into the name of the trust.
Okay.
And your spouse, your partner, she has 3 or 4 deeds, 3 or 4 pieces of real estate.
Yeah.
Again, 3 or 4 deeds, transferring the property from her name individually into the name of the trust, or
Okay.
into the name of the trustees of the trust.
Yep.
And then you and your wife could serve as trustees of that trust. You're going to be the managers of it.
Okay.
If it's a revocable trust, you can sell the real estate, take the funds from the real estate out of the trust and use it for your own personal use in any way that you want.
Okay.
It's revocable. That you have just as much access to the funds in that trust as you do as to the money in your wallet. It's under your complete control. It's
Okay.
revocable.
Okay. What if it's irrevocable?
If it's irrevocable, then what we're trying to do there through the irrevocable trust is now we're trying to accomplish not only the avoidance of probate that we can accomplish with the revocable trust, but now we're trying to accomplish other goals. Maybe they are tax planning goals. Maybe they are estate tax planning goals. Maybe they are helping us qualify for a government benefit that has an asset limit. So now, because when we put assets into an irrevocable trust, we don't have the same access to it as we do with the revocable trust.
Okay.
We're putting the assets now just a little more out of our reach. In other words, with the revocable trust, I said the funds in the revocable trust, you have just as much as direct access as you do to the money in your wallet or in your pocket. With the irrevocable trust, depending on what you're trying to accomplish, you don't have that immediate and direct access to the funds in the irrevocable trust. So like, for example, with the irrevocable trust, yes, we want to avoid probate. But now maybe what we want to do is that because we have a significant amount of assets, now what we want to do is that we want to do some estate tax planning and we want to do some income tax planning.
Okay.
So what we would do there is we would put the assets into the trust, into the irrevocable trust, and then you as the grantor, you as the person putting those assets in, now what you're going to say is I give up all access to those funds. I give up all of my right to those funds. I want them in the trust for the benefit of my children, but I don't want to give them to my children now because of their age or because of their circumstances in life. I don't want to give it to them outright. But I do want to get them out of my name. I don't want the income that's generated from those assets. I don't want the growth and appreciation and value associated with those assets. I don't want those in my estate.
Okay.
So I'm going to make a complete transfer. And I am going to give up my direct access, and I'm going to give up my right to ever revoke the trust. So now it's final.
Yeah.
You've made just about a completed gift of those assets. You might have some control over them, but you can no longer use them for your direct benefit.
That's interesting.
That's the irrevocable trust. And that's used often when we're doing long-term care planning as well as estate planning. Because with long-term care planning, sometimes in order to qualify for a benefit to help pay the cost of the nursing home, we need to reduce our assets. And we can reduce our assets in a safe, secure, comfortable way by putting them into the irrevocable trust rather than giving them outright to people at this time. We put them into an irrevocable trust.
Okay. Is there a time limit?
Well, for the government,
For the government in that particular
so for the
sense.
government, for the government benefit that trust would come into play for would be the main care long-term care benefit.
Okay.
The cost of a nursing home today is between $10,000 and $12,000 a month. There are benefits. There are government benefits out there. A veterans benefit, the main care benefit, that will help pay for that cost, but we have to meet certain asset limits. And the irrevocable trust is something that we use. We place assets in that irrevocable trust, and then we start a 5-year period running.
Okay.
Because when somebody files the application for the main care benefit, we have to tell the state what they did with their assets for the last 5 years. Assets given away or distributed without compensation are gifts. And those gifts made within the 5-year period of applying for the main care benefit are going to result in a period of ineligibility. So one of the planning measures is, one of the strategies is, we use the irrevocable trust with the owner of the assets giving up just about complete ownership and control of those assets. That starts the 5-year period running. At the end of 5 years, we don't have to mention those assets when we apply for the government benefit.
Mm-hmm.
The assets continue to be held in that irrevocable trust, usually until the parent passes. Then they're distributed to the children.
That's why it's so important to get the planning. Start planning, because if nothing else, there's a 5-year window if you want to protect your assets.
Right,
that
that's
you better
one of
be
the
thinking
strategies.
about.
That's one of the strategies is the 5-year trust strategy to preserve your assets.
And you can walk them through their needs all the way through to what they need to do at the end of that period. Right. So if they come in when 55, 60 years old, when they're thinking about retirement, this is part of that bundle of sticks, so to speak.
Exactly.
That may be fitting to them and it may not be, but let's talk about it.
Exactly. So you're right. The earlier someone comes in, the more we can talk about that 5-year plan. And of course, it depends on their assets and income otherwise.
I see a lot of evidence of deeds coming into the town, municipality, with irrevocable trusts, granting ownership to children or siblings, and that, for instance, I'm going to live there. I reserve the right to live there, life estate of it.
Yeah.
And I'm going to pay the taxes, and I'm going to do certain things.
Yeah.
How custom can that be to what the individual may need, John? If they come to see you and say, gee, I want John, Fred, and Sally to have my property when I'm done, but I want to live there until I can't anymore.
Yeah.
And
that's very common.
Want to do that, but I'm going to be responsible for the taxes, and they'll be responsible for the insurance, and
so we spell all that out in the trust document.
That's all spread right out.
Yeah.
So that everybody understands.
Everybody understands. We like to have the family involved as much as possible so that they understand what mom and dad are doing, what they want to accomplish, and how they can play a role in it. But what you talk about is very common for us to put personal residences, family homes, into the irrevocable trust, family camps, cottages, put those into the irrevocable trust, and we do exactly as you say. We spell out that even though these assets are in trust, mom and dad still are going to be able to use the home, live in the home. They're going to have to mow the lawn and put a new roof on and pay the taxes and everything else. Nothing really changes for the mother and the father or for the elder, except on paper.
Right.
And even with the irrevocable trust, we make the parents, the elders, quite often we make them the trustees.
Mm-hmm.
So they're the managers of it as well.
That's fantastic, because sometimes you see where that doesn't work out in their best interest, because they weren't planning to see what the end of the day was going to be like, and they get left hung out there by whatever reason.
So we never leave them hung out there, though.
No, that's the key to getting good advice, to make that plan and make it perfect the way it should be.
Yeah, and safe for the senior.
Right.
In other words, just transferring the home to the children, no, we do not recommend that. We recommend maybe transferring the home to the children and reserving a life estate to the parents, or we recommend transferring the home into the irrevocable trust, giving the parents the right to live there for the rest of their lives.
Right.
But
you can't plan enough, I guess is what I'm saying, because even if they go to a financial planner or they go to somebody else, there's nothing like the person understands elder care to see or at least look at what your needs are going to be, what you want to get done, and how you want to get them done. It's fairly simple. In retirement planning, I would say that we talked about in the previous show that the trust is a part of that retirement planning. There's many little caveats that go into retirement planning that we have discussed over a period of time here, from advanced directives right down through to the living trust, or the trust that we have to set up. So you cover the whole gambit from that.
The other type of a trust, a very important type of a trust, is the supplemental needs trust. That's a trust that the purpose of that trust is not so much to avoid the probate process with the assets, but to put assets in trust for the benefit of a disabled individual.
That's interesting.
And it's a certain type of a trust, supplemental needs trust they call it. It's recognized by federal law. And assets put in that type of a trust do not count towards the asset limits that might be allowed for a disabled individual in order for the disabled individual to qualify for government benefits. So, for example, here in Maine, in order for an individual to qualify for the Maine Care health care benefit, their income has to be below the poverty level limit, and they can only have less than $2,000 of assets in the bank. So when we're dealing with with parents, elders, who have significant assets, or even just a fair amount of assets, or a modest amount of assets, and they're going to leave those assets to the disabled child, if the disabled child receives those assets, $100,000 of assets, puts them over the government benefits limit, they're going to lose their government benefit. But if we put them into a supplemental needs trust, if the assets are put into a supplemental needs trust for the benefit of the disabled child, then the disabled child stays qualified for the government benefits, and then has the assets in the supplemental needs trust as well. So the assets in the supplemental needs trust are meant to supplement the government benefits, not supplant, not to take the place of the government benefits.
Yeah.
So when we're dealing with folks who have disabled children, we very often recommend that they leave assets to them in a supplemental needs trust. Not outright, not into a revocable trust, but into a supplemental needs trust, so that the disabled individual can continue to qualify for the government benefit and have their lifestyle supplemented by the inheritance that they get from their parents.
That's important.
Through the supplemental needs trust. Very important.
What about guardianship in trusts like that, John?
Well, again, by thinking ahead, if we are planning for a disabled individual, then the trustee of the supplemental needs trust is going to have control over those assets.
Mm-hmm.
Now, we have to remember, now you use the word guardian. A guardian has control over the physical person of the body.
Okay.
If the physical body of the person.
Mm-hmm.
A conservator has control over the person's assets.
Okay.
So the
That's
trustee in this case kind of acts like the conservator of the assets that are in trust, but the disabled individual still might need a guardian.
Yes.
For the health care decisions, living conditions, diet, different things like that, because the guardian has control over the person. Conservator, control over the assets.
I wonder how many people out there really know that difference. I bet they don't. But it's all a part of planning.
Yes.
And it all needs to be done. And boy, I've learned a lot out of this show. You know, it's just amazing to me because I didn't know it all, but I thought I knew a lot, but I don't know as much as I thought I did. It's so I'm going to qualify for that planning very soon, and I think it's important that other people do that because there's so many nuances to the whole retirement planning scenario. You know, what do you want to do? Do you want to, you know, if both of you, couple comes in and they've got two split families like we talked about, how do you reconcile equality? How do you work through that? And just having somebody to talk to sometimes does help to say, well, gee, I hadn't thought about that, or you know, get in early, get on the board.
Get in early, and like with us as elder law lawyers and estate planners, we do a lot of listening. We do a lot of listening so we can understand the client wishes, goals, their family, their health, their finances, their children, disabled children.
That's so important.
And put a whole package together for them, recommendations along the lines that would accomplish the goals that they
want.
Feel important.
But if they come back 5 years and say, Mr. Neal, I want to change. Things have happened. How do we change trust? How can we do that, John?
Yeah, it's all doable. The advance directives where we name somebody to be our agent, we always like to have a backup agent, a primary agent and a backup agent. But if for some reason or other, because the agents have moved or the parent has just simply changed their mind about who they want to act for them, then yes, those documents can be changed, can be amended. Same thing with the trust. Same thing with the last will and testament. They can all be changed. The only document that you cannot change is the irrevocable document that cannot be changed in certain particular ways. It cannot be changed because that's the irrevocability of it.
Okay.
And the things that you can't change with the irrevocable document is that you can't say, I now want these assets to be used for my own benefit in the irrevocable. Right. You can't change it. Once you say it's out of my reach, it's out of my reach, then you can't go back on that part of it. So a lot of thought needs to go into that.
Let me play a little devil's advocate here. Let's say that I have created a irrevocable trust with my property, and the kids are going to have it, and then I get dementia, and I want to change it. And I'm not mentally capable of knowing what I'm doing. How does that all evolve? Does it have to stay the way it was?
Well,
Can
then
it change?
If you yourself are not competent to sign a new trust document or an amendment to an existing trust document, then you're right, you can't do it. But if you, while you were competent, if you executed, put into place a valid, durable power of attorney, that gave your agent the authority to make the changes, then your agent could make the changes.
Okay.
But no, you can't. In Maine, you have to be competent at the time you're signing the document. You don't have to be competent tomorrow.
No.
You just need to be competent today to be able to understand at the time the discussion is going on. You need to understand the nature of your family, the nature of your assets, and the nature of your distribution pattern.
Yeah.
At the time.
Too many times, Alzheimer's, dementia, different things. It's the aging process that we all go through. And too many times that sneaks up on us, and we're left, what do we do now?
We see that.
The family doesn't know what to do. You know, they can't get an answer out of me or for whatever reason. And then they're all frustrated.
We see that.
I know, and I've seen it, and it's sad to see that. That's why I'm glad that you do elder care, because it does mean a lot to a lot of people. It really does.
And it's much needed.
Yes, it is.
Yeah.
And what's your telephone number again? Should somebody want to call?
At the office, 660-9191.
9191.
You might give us a call.
Yeah, you got that. All right. Well, thank you very much, John. This time here we've spent talking about trusts, and we've covered many issues in this series, and I appreciate the time and the candor that you've used in handling all these issues.
Thank you, Clyde, for having me.
Thank you.
Appreciate it.
And we'll see you next time on Kennebec Valley Forum.